kita. PC boleh kuat kan.
Oh gila. Bab banyak tawakal audio, aku tak nak tawakal.
Kan. Saya kabel.
Kau buat speaker. Speaker nak sampai. Tak mau pun speaker kau. Letak dekat speaker mic. Once tak main speaker.
Itu ada.
Main speaker.
Kabel ada. Tak sampai ke?
Tak sampai.
Saya kalau sampai nak tahu ni.
Tepi.
Saya ada kabel panjang GMB ya.
So, good morning to you, ladies and gentlemen. Today marks the final day of the Permanent People's Tribunal proceedings on the session on state crimes allegedly committed against the Rohingya, Kachins, and other groups in Myanmar. So we are thankful for your presence here today, knowing full well that today is the Muslim New Year, and there is an interesting coincidence with the Jewish New Year this year too, at the same very day. So we are thankful in many ways to have these tribunal hearings here in Malaysia. I really think, and we really think, it's a timely event. When we first had the preliminary session in London in March this year, with a view to hold the final session in September in Kuala Lumpur, little did we anticipate the acceleration of atrocities in Rakhine State in August. So the whole world was outraged, and we were even more determined to address the state crimes issue. Everything seemed to fit in, so you can imagine our surprise when Aung San Suu Kyi made that speech on the second day of our tribunal proceedings. So, that's the final day. We will proceed with the reading of the judgment, as it is a tradition of the Permanent People's Tribunals. All of the members of the panel of the judges will read some excerpts of the judgment. It is a long judgment, so it won't be easy to read the full judgment. We will read some important excerpts from the judgment, and you will be the judgment available, the full judgment, very soon. So we will say, just regarding the proceedings, you all are aware that in strict compliance with the statutes of the Permanent People's Tribunals, all the steps and official documents relates to the case of these sessions, from the results of the London opening session to the first formal convocation of the Kuala Lumpur event to the official program and the indictment, have transmitted to the representatives of the Myanmar civil and militant authorities, to the more directly convened international agencies and governing bodies, and Myanmar authorities notified and invited to present a defense. So while no answer was received from the Myanmar government, a formal acknowledgement of the invitation has been received from various of the above-mentioned international agencies with a request to be kept informed of the results of this session. The right to defense, which is central in the statutes of the tribunal and has been a carefully observed practice throughout all its proceedings, has been regularly communicated to the concerned parties in due time. As no answer was received at the beginning of each of the 3 days of public audiences, I have asked if any representative of the Myanmar government was present in the room, and no response was received. According to the statutes, in the absence of any response, the Permanent People Tribunal's procedures of an ex officio defense was activated, and the resulting text was read publicly by the representative of the Secretariat of the PPT. The full text of the speech given by the State Councillor Aung San Suu Kyi on 19 September 2017 in an address to the assembled diplomatic corps in Naypyidaw, which had already been listened to collectively by the panel of the judges and which was formally and partially replayed in front of the audience, was assumed to be the most complete and updated expression of the position of the Myanmar authorities. Because of its relevance, it is considered as an integral part of these proceedings. So now we will start with the reading of some excerpts of the judgment. So Judge Helen Jarvis from Cambodia will start with the first part of the presentation of the facts regarding the alleged crimes committed against the Kachin people.
Situation of the Kachin people. We are still birds in a cage. So the first Kachin witness before the People's Tribunal on Myanmar in Kuala Lumpur summarized the condition of his people. After reading a long list of specific cases of torture and execution suffered since the 2011 breakdown of the 17-year-long ceasefire between the Kachin Independence Army and the Burmese Army. Since achieving independence from the UK on the 4th of January 1948, the state of Myanmar has been at almost ceaseless war with approximately 40% of its 55 million people, who make up the country's 135 recognized nationalities, as well as minority religions and other unrecognized ethnic groups. Kachin State, the most northerly of the country, in the foothills of the Himalayas bordering China and India, is one of the 6, later to become 7, ethnic nationality states that were created when Burma became independent in 1948. In the 2014 Myanmar Population and Housing Census, the state's population was reported as being 1.689 million people, or 3.3% of the total. These people, numbering between 1 to 1.5 million, are largely residents in Kachin State, but also form a substantial part of the population of the northern section of Shan State. Under British colonial rule, many of these previously animist people became Christian. War and increasing marginalization have been the dominant features of life for the Kachin people since at least the early 1960s. The 1962 military coup ushered in more than 3 decades of war, during which time it is estimated that many previously Kachin towns and villages were destroyed and people killed. And under the national policy of Burmanization, substantial inward migration led the Kachins to progressively lose many of their customs and traditions, including, for many in new generations, competence in the 6 Kachin languages. A ceasefire from the 24th of February 1994 until the 9th of June 2011 brought an end to this hot fighting, but led paradoxically to an ever-increasing militarization of the region, with the stationing of many Central Army battalions throughout the state and the introduction of an oppressive developmental model involving massive alienation of traditional lands and natural resources, notably the precious jade of the Kachin people, accompanied by increasing dispersal and marginalization of Kachins through significant urban immigration of lowland Burmese people, including replacing many Kachin animist or Christian sacred places with Buddhist shrines or pagodas, generating demoralization and a debilitating drug scourge. This shift is reflected in the findings of the Myanmar 2014 census, that 64% of the population in Kachin reported as Buddhist, while just 34% reported as Christian. Since fighting resumed in Kachin State and northern Shan State in 2011, with indiscriminate targeting of civilian areas and military airstrikes, it is estimated that 10% of the population has been displaced. At least 120,000 people are now languishing in IDP camps, 2/3 of which are under the control of the Kachin, and these have faced numerous restrictions and denials of access for humanitarian aid. Written and oral testimony of the suffering of the Kachin people was presented to the opening session of the tribunal by, among others, representatives from the Kachin Women's Organization. This session in Kuala Lumpur received both written and oral testimony from further witnesses, including from the Kachin National Organization and the Kachin Women's Association of Thailand. Expert testimony, including original video footage of military attacks and their aftermath, was presented. In addition, a number of witnesses testified in camera of crimes they had suffered personally and had felt compelled to leave their homeland in fear of their lives following forced labor, serving as porters for the Myanmar army, beatings, torture, execution, or jailing, enforced disappearance of friends and relatives, and/or military attack on their villages. The direct testimony presented to the tribunal corroborated a wealth of information given in a number of substantial written reports by various human rights organizations and researchers that were also submitted to the tribunal by the prosecution.
Thank you, Judge Jarvis. So let me remind the audience that phones must be turned off or silenced. So now Judge Shadi Sadr will read some excerpts regarding the presentation of the case of the state crimes committed against the Rohingya population.
Thank you. The Rohingya are an ethnic minority of Burma, Myanmar, who have been subjected to prolonged, institutionalized, and systematic denial of identity and rights for decades. The integral and fundamental parts of their identity, such as language, culture, religion, and history, have been criminalized, prohibited to be educated, suppressed, and contradicted. The government of Myanmar has denied progressively the right to nationality of Rohingya through different laws and policies, which has subsequently caused the deprivation of civil, political, economic, social, and cultural rights. The gross human rights violations in Burma, Myanmar have been massively documented by the UN, international NGOs, and Myanmar human rights and civil society organizations. The prosecution presented several fact-finding reports to the tribunal as evidence. They confirmed the testimonies which were heard by the tribunal in London and Kuala Lumpur hearings as the following crimes. 1. Arbitrary arrest and torture. The tribunal, both in London and Kuala Lumpur sessions, heard several accounts of the arrest of civilians by the armed government forces. They include children and young people. Several witnesses testified before the tribunal about the different types of physical and mental torture which they had been subjected to while in detention. 2. Enforced disappearance. Both the fact and expert witnesses testified before the tribunal about many cases of those who had been arrested by the government forces have been disappeared since then, and the families do not know their fate or whereabouts. The survivors of the recent crisis have also reported about missing family members. 3. rape, and other forms of sexual abuse. The tribunal heard first-hand horrific accounts of Rohingya women who had been raped in their homes, their villages, and the IDP camps by the military forces. They also witnessed the other women were raped or gang raped in front of their eyes. The memories of the victims of rape are usually bonded with horrendous scene of the killings, disappearances, and injuring of their family members, their children, and neighbors, burning their homes, and destruction of their belongings. The Rohingya women were also subjected to other forms of sexual, physical, and psychological sexual violence, such as violations of body's integrity by groping their private parts of their bodies during body search, as well as forcing them to undress in public. The four safe-based testimonies also presented a horrific pattern that the Rohingya women who had been raped by the military were raped again several times and for months by the smugglers and other people who took the advantage of the situation in all their way from Rakhine to Thailand and Malaysia. As a matter of fact, traumatized and impaired, they do not often receive the support they are in desperate need of from the UNHCR here in Malaysia. 4, extrajudicial killing and causing bodily harm. The survivor of the Rohingya persecution shared beyond imagination experience with the tribunal, their fellows who had been severely injured, shot dead, or slaughtered with knives or burned alive. Several massacres in different villages across Rakhine State were reported to the tribunal by the expert witnesses, and these reports also included some details about throwing the bodies of the victims in mass graves. 5, confiscation of property and destruction of buildings. Several accounts presented to the tribunal clearly describe looting, confiscation of property, and destruction of homes, shops, workplaces, mosques, and other buildings and entire villages in the location where Rohingya people had lived. In many cases that were brought to the tribunal, armed government forces or non-state actors were reported to have taken all valuable belongings of the Rohingya people and subsequently burned or destroyed the buildings. There were several accounts of confiscation of land and other properties by either the government or ultra-religious Buddhist groups. 6, internal displacement and forced exile. Over only the course of 3 weeks in August-September 2017, more than 400,000 Rohingya, mostly women, children, and elderly, had to flee their homes and entered Bangladesh. However, the number of Rohingya refugees who have had to escape state persecution over the past few decades is much higher than that, with Bangladesh alone soon hosting 1 million Rohingya refugees in total. The tribunal heard several testimonies of Rohingya refugees were forced to leave their homes and their country, Myanmar, by border guards and other forces accompanied by Rakhine Buddhist mobs, sometimes including monks. According to the testimonies and other evidence, forced exile occurs as a result of direct pushing the population of the borders villages out of the country, often by terrorizing them by burning their homes and seizing their belongings and killing their relatives and other villages, or indirectly through imposing severe and intolerable hardship on them.
Thank you, Judge Sadr. Now, Judge Zulaiha Ismail from Malaysia will finish the part of the presentation of the case with some parts of the state crimes committed against other Muslim groups.
Thank you. Serious violations of human rights and allegations of crimes against humanity of other Myanmar Muslims. The Permanent People's Tribunal received its third complaint from the Myanmar Muslim community in July 2017. And while allegations of persecution have been somewhat less catastrophic, tragic, and severe in intensity compared to the Rohingya community, they nevertheless demonstrate a purposeful institutional strategy of outright abuse towards other Muslims in Myanmar. Records of human rights abuses of the Muslim community in Myanmar became conspicuous with the coup under General Ne Win in 1962, which established the superiority of the Burmese Buddhists over other ethnic groups. Since 2012, the situation has deteriorated further, and much to the disappointment of the Muslim community, the transition to the joint National League for Democracy with military rule in 2015 has seen instead the acceleration of human rights abuses, plus documented evidence of crimes against humanity towards Muslims in general. In the closing session of this tribunal hearing in London in March 2017, the panel of judges found identity framing by exclusion, the process of creating Myanmar as a supreme Burman Buddhist entity, to be the prime ideological cause of ensuing allegations of war crimes and crimes against humanity towards other ethnic communities in Myanmar. From a historically pluralistic society of diverse ethnicities and religions, Myanmar underwent a demographic transformation process that was buttressed by the passing of its citizenship law in 1982. In targeting the Muslim community, which had traditionally been accorded equal citizenship rights, the new law required all Muslims to show proof of ancestry dating back to 1824. Those who held full citizenship certificates, called the NRC, had to surrender them when the enforced renewal deadlines at ages 12, 18, and 35 came up, as it was an unwritten law that a full citizen cannot be a Burmese and a Muslim at the same time. In return, they were asked to obtain national verification cards signaling a lower status ID that does not acknowledge full citizenship, rendering the holder ineligible for passports and the loss of freedom of movement. The alienation cum rejection of the Burmese Muslims in the political, economic, and social sectors then becomes a corollary to the reduced status of the Burmese Muslims. It was reported that currently there are no Muslims in parliament, the military service, the police service, administration, and academia. From the research reports presented to the tribunal and the testimonies of expert witnesses and 4 witnesses, this systematic and institutionalized persecution of Burmese Muslims could be examined in several ways. 1, increased difficulties in securing an NRC. Such denials also translate into reduced job opportunities and reduced financial standing for the individual. 2, institutionalized forms of religious intolerance contravening the Universal Declaration of Human Rights, such as restrictions in building and repairing mosques, sealing of madrasas or Muslim schools, reduced access to communal prayer services, creation of Muslim-free villages indicating characteristics of an apartheid system, increased evidence of hate speeches and discriminatory campaigns, for example, boycotting Muslim-owned businesses. Sporadic cases of violence initiated by ultra-nationalist mosques. Also, forced evacuation of an entire village to a Buddhist cemetery after a mosque was bulldozed. The Mektila massacre March 2013 saw the brutal murder of 32 Muslim students and 2 teachers, followed by pillaging and looting and the displacement of 12,000 villages. From the foregoing testimonies and documents submitted, the tribunal is of a view beyond reasonable doubt that crimes against humanity were committed against the Muslim civilian population in Myanmar.
Thank you, Judge Ismail. Now we will continue with the next part of the judgment, which is some important notes about the state of Myanmar and the question of identity. That was very important for the qualification that we will do later of the facts. So Judge Nello Rossi from Italia will take care of this part.
The state of Myanmar, a limited democracy and military guardianship, intolerance and the lack of justice. Even after the notional return of the country to democracy, the 2008 constitution has preserved a dominant and privileged role for the power of the military, guaranteeing them 25% of the seats in parliament and creating de facto a democracy under the military guardianship. The heads of Burmese army, who have spent the last 70 years at war with country's ethnic minorities, retain effective control over the economy, over natural resources, and over the riches of the country, and appear strongly interested in maintaining a degree of internal conflict in order to legitimate the idea that only the military can preserve the state and consequently their dominant position. Furthermore, these ongoing conflicts ensure that the military leaders can be seen as the only true representative of the country in the international arena. Therefore, most observers stress that the Burmese military remains the major obstacle to achieving the key democratic and human rights reforms and to carrying out the perspective of becoming a state that acknowledges its ethnic diversity, chooses to be really federal in structure, and favors religious tolerance. This role of military as an agent of discrimination between the ethnicities can be better understood in an historical perspective. As Azim Ibrahim recalls in his book, The Rohingyas, Inside Myanmar's Hidden Genocide, there is ample evidence that in the Burmese legal framework and in practical decision, the Rohingya were not seen as being especially different in the period of democratic rule up to 1962. This relative tolerance started to change once the military came to power. In that year, the military leaders decided if they could not have an ethnically pure state, which have meant giving up all the wealth in the border areas to the north and east, they would use being Buddhist as a test for being a proper citizen of the state, adopting the logic of equating being Burmese with being Buddhist. The Buddhist extremists adopted this approach, and unfortunately, the democratic opposition did not adequately oppose this sectarian definition of what is meant by being Burmese, with the consequence that the Myanmar government could play politics by using race, religion, and nationality, a quotation, and then almost all Myanmar ethnic have started hatred against Rohingya and hatred against Islam, and accusing collectively These people are illegal migrants. From an interview with Rohingya politician, then sitting in parliament, 2015, left anonymous for safety. The framework of a limited democracy is completed by the absence of an independent and authoritative judicial power. During the 51st session, March 2016, the Asian Legal Resources Center stated that Myanmar and these people are, for all practical purposes, still under the influence of militarization that has gripped the country since 1959, and has recalled that the people of Myanmar and their institutions don't have a memory of independent justice institution. Concepts like presumption of innocence, right to silence, and independent adjudication of disputes have never been given a chance to take root in the country. This state of affairs contributes strongly to the abuse of power and to the crimes against minorities, and guarantees the impunity of the powerful.
Thank you, Judge Rossi. Now, Judge Nursyabani Kajasunkana from Indonesia will continue with the part related to identity and citizenship before going to the qualification of the facts.
Thank you. The 2008 Constitution keep alive Myanmar's incredibly restrictive approach to citizenship, inspired by the idea that only those ethnicities which are considered national of Myanmar, namely Arakanese, Burmese, Chin, Kachin, Karen, Kayah, Mon, or Shan, as enumerated in the Election Act of 1948, are able to have citizenship and to give that citizenship to their children, and that any other group outside those nationalities has to prove their presence in the territory of Burma back to 1823, even if in 1990 an official list of 135 different ethnic groups in Myanmar was made public. On this legal basis, membership of the country has been denied until now to Rohingya, treated in the Commission report as Muslim of Rakhine, as the government did not accept even to name them with the name they had used for decades and they recognized as their own. Even though their presence was documented from at least the 18th century in the area of what is now Rakhine State, in open breach of reasonableness and of the 1961 United Nations Convention on the Reduction of Statelessness, which states in Article 1, a contracting state shall grant its nationality to a person born in his territory who would otherwise be stateless. These laws and governmental decisions on identity have also affected other Muslim groups. The tribunal was informed by several different witnesses of their experience that to be accepted as citizens of the country, they were given to choice of either keeping their Muslim religion and recording of foreign ethnicity, namely Malay, Bengali, Indian, or possibly another of the other nationalities like Shan or Karen, or renouncing the religion and be recorded as Buddhist with Burmese ethnicity. Even the Rohingya are the ones in the worst position. The whole question of managing identities in the state of Myanmar is a matter of deep concern and, in the opinion of this tribunal, is one of the main causes of the conflict and atrocities which are under scrutiny and which we will analyze below. Two different analyses of the genocidal social practice both establish the construction of identity as its first stage, stigmatization and construction of negative otherness in Frankenstein periodization and classification in Stanton periodization. In the state of Myanmar, there is a permanent process of classification, stigmatization, and construction of negative otherness against different groups. Firstly, the various groups that were not recognized as national of the country, if they cannot prove their present back to 1823, which is an almost impossible task. Then, even other Muslims who were members of the accepted nationalities. And later, even the non-Burmese accepted nationalities as testified in evidence before this tribunal regarding the case of the Kachins group, and probably also the case regarding other non-Burmese groups that did not have a chance to present their cases before this tribunal, but for which some information was provided, albeit not in an explicit and documented way during the proceeding. Ethnicity and religion have played a very important role in this construction of negative otherness as a tool to divide the population. The state of Myanmar has more and more developed a nationalistic and racist understanding of its constituency as Burmese Buddhist community instead of the original Union of Burma, plurinational and multi-religious community. In our analysis, this was the first step for legitimizing and fueling the atrocities described in the previous section and that will be qualified below regarding the alleged commission of war crimes, crimes against humanity, and genocide. Moreover, the growing anti-Muslim understanding of identity was quickly linked in the widespread connection made in the media between Islam and terrorism. Indeed, Aung San Suu Kyi's speech made during the proceeding of the tribunal, as included as part of the defense case, qualified attacks against police and outpost station as terrorist attack and invoked the Anti-Terrorist Act to prosecute them. Use of that label served to justify forced displacement, massive attack on civilians, burning of the villages, and other action committed by Myanmar security forces, other paramilitary groups, or by Rakhine nationalists, which were on two separate occasions, in October 2016 and August 2017, presented only as a consequence of those attacks, even if a lot of those prosecutions were committed long before the attack.
Thank you, Judge Nur Shabani. So now I will do some summary of the qualification of the facts regarding the three crimes that were alleged. So first, war crimes, then crimes against humanity. I will summarize them, and then I will read a little bit more about the crime of genocide that needs a bit more analysis. So regarding war crimes, from the full and detailed documentation admitted during the tribunal session and described about in the part of the presentation of the cases, The accusations advanced in the indictment regarding war crimes against the Kachin people of northern Burma, as defined by the Rome Statute, have been fully proved. So the list includes all the following acts of the war crimes that were proved. It's so long. But in particular, the tribunal believes that systematic targeting of civilians and all of the other acts committed by the Burmese army must be qualified for all legal purposes as war crimes committed as a part of a plan or policy or as a part of a large-scale commission of such crimes. The course of historical events demonstrates that Kachin state has undergone for many years a kind of internal armed conflict, war of self-determination, to which it's applicable the Geneva Convention of 12 August 1949, according to the explicit recognition of the 1973 General Assembly Resolution 3103. In actual fact, the perpetrators of the crimes enumerated above are combatants, the victims are not combatants. The criminal acts of military soldiers may be said to serve the ultimate goal of a broad military campaign. The crimes are committed in the context of official duties. In other words, the attack is intentionally directed against the civilian population or against individual civilians not taking direct part in hostilities and against civilian objects, that is, objects which are not military objectives. The tribunal watched on the screen the images of shellings on wrecked villages, was shown photographic evidence of dead bodies and of tortured persons, and heard accounts of violence of witnesses and of victims. From the foregoing testimonies and documents submitted, the tribunal is of the view, beyond reasonable doubt, that the state of Myanmar is guilty, therefore, of war crimes perpetrated against the Kachin people. So that's the first charge. Then we will move to the second charge, which is crimes against humanity. From the foregoing testimonies and documents submitted, the tribunal is of the view, again, beyond reasonable doubt, that crimes against humanity were committed against the Rohingya, against other Muslim civilian population in Myanmar, and against the Kachin, amounting to the following: murder and extermination, just such as the Meirtila massacre of Muslims, the numerous extrajudicial killings of Kachin and Rohingya populations, several massacres of Rohingya people in different villages across Rakhine State, the extermination or murder of Kachin civilians, including women, children, and the elderly, by military forces, deportation or forcible transfer of population. In the case of the Kachin people, the creation of a large number of IDPs, internally displaced persons, now estimated over 120,000, the internal displacement and forced exile of more than 400,000 Rohingya, mostly women, children, and elderly, who had to flee their homes and enter Bangladesh during only the last 3 weeks, joining hundreds of thousands forcibly displaced before in a number of different waves. Imprisonment or other severe deprivation of physical liberty in violation of the fundamental rules of international law, such as the forcibly confinement of Rohingya in the camps, suffering from starvation and very poor living conditions, the severe deprivation of physical liberty in violation of the fundamental rules of international law, denial of citizenship rights which had earlier been accorded to them, arbitrary arrest of Rohingya civilians by the armed government forces, including children and youngs, torture, such as the different types of physical and mental torture to which the Rohingya and the Kachin had been subjected to while in detention, rape, sexual slavery, and other forms of sexual violence, such as the cases of rape, sexual violence, and other forms of abuse charged in the Rohingya and Kachin testimonies, either publicly and in in-camera sessions. Persecution against any identifiable group, which is applied to the three groups, the Kachin, the Rohingya, and the other Muslim groups in Myanmar. Enforced disappearance of persons denounced in the case and proved in the case of the Rohingya and the Kachin, and the crime of apartheid, like the project to create Muslim-free villages, the different practices of discrimination either of the Rohingya and other Muslim groups. And finally, we will move to the charge of genocide, and I will read a bit more because we have to explain the position of the tribunal on that charge. The term genocide was coined by the Polish jurist Raphael Lemkin, who wrote that by genocide we mean the destruction of a nation or an ethnic group. Lemkin went on to argue that genocide has two phases: one, the destruction of the national identity of the oppressed group; the other, the imposition of the national identity of the oppressor. The concept of genocide was later codified in the United Nations Convention on the Prevention and Punishment of the Crime of Genocide, approved in 1948 and ratified by the state of Myanmar in 1956, later included in the Rome Statute for the International Criminal Court in 1998, which defines genocide as any of the following acts, we will talk about the 5 acts later, committed with intent to destroy in whole or in part a national, ethnic, racial, or religious group as such. The distinctive feature of genocide, according to Lemkin and to the Convention, is that it aims to destroy a group rather than the individuals that make up the group. The ultimate purpose of genocide is to destroy the group's identity and to impose the identity of the oppressor on the survivors. This idea gives us a useful insight into the workings of power systems in the modern era, and particularly in the case of the state of Myanmar, which is under scrutiny in this judgment. Lemkin wrote also that the nation-state has tended to destroy the identities of ethnic and religious minorities within its boundaries and impose a new identity on them, the national identity of the oppressor. That is the objective of the process which started in Myanmar decades ago in respect to the different non-Burmese groups, even if it was not developed at the same pace with all of them. So we will analyze now the question of the general intent, which is a necessary element for the qualification of genocide. Many sociological works have shown that genocide is a process which involves different kinds of actions and so different stages, even if they are neither linear nor exclusive. Professor Gregory Stanton, past president of Genocide Watch and former president of the International Association of Genocide Scholars, testified before the tribunal, analyzing that process in 10 different stages. The report, Countdown to Annihilation, referring explicitly to the case of the Rohingya population in Myanmar, which was presented before the tribunal in the London opening session and provided to the judges in the current proceedings as a document, applied a 6-stage model periodization of genocide to the case of the Rohingya group. They found that the first 4 stages had been reached in the then current situation of the Rohingya in Myanmar: stigmatization, harassment, isolation, and systematic awakening, and that the stages of extermination and symbolical enactment could take place at any moment. Moreover, the 1988 Peace and Development Council Rohingya Extermination Plan, submitted by the prosecution in evidence and also verified by the International State Crime Initiative, precisely articulated a government policy not to provide the Rohingya with citizenship cards. The tribunal found that the denial of the Rohingyas' right to nationality has caused them institutionalized deprivation or restrictions of the other basic rights, such as the right to education and health services. The 1988 Rohingya extermination plan outlined the government policy on denying the Rohingya any access to higher education, right to property and own land, building and shop or other economic rights, stating, quote, any such properties under their existing ownership must be confiscated for distribution among the Buddhists. In all of this analysis and from other evidence presented before this tribunal, it is clear that the general intent of the government of Myanmar has been to destroy, and in the case of the Rohingya population and the Burmese Muslims, also to deny the identity of these different groups as a part of the Myanmar community. That intent applied not only to the three groups under scrutiny, Kachin, Rohingya, and other Muslim groups of Myanmar, but also probably to other groups which were not part of these proceedings, even if few references about their situation were provided to the tribunal. Although the forms of implementation of that general objective of identity destruction have been different, it is important to highlight that all the non-Burmese groups and the Muslims Burmese are suffering a common process in Myanmar. The stages at which that process has been reached at the present time are not the same, which only means that some groups could suffer in the near future the same process other groups are suffering today. Accordingly, we believe that combining in a single tribunal the analysis of these various genocidal practices developed by the state of Myanmar against different parts of its community could be a way to strengthen the ties among those communities in the face of the genocidal aims of the state of Myanmar. Now we move to the implementation of genocide. Even if the general objective of destruction of the group applies to all the non-Burmese groups, the implementation has reached different stages regarding each of the groups. First of all, even in the legal structure of the state of Myanmar, the Rohingya group has been wiped out. In the current situation, the Rohingya cannot be Myanmar citizens as Rohingya. That group is not recognized as part of the community, and it is even prohibited to use the word Rohingya to refer to them. That is the last stage in any analysis of genocidal social processes as either denial or symbolical enactment, which means not only that the group is attacked in a material form, with the intention to annihilate it, but even its symbolical existence is also denied. In the case of other Muslims, if they state their religion as Muslim, that is recognized and recorded, but then is interpreted to mean that they cannot be recognized as ethnic Burmese, and they are forced to add a second qualifying ethnicity nationality, such as Karen, Shan, Indian, Pakistani, Bangladeshi, regardless of whether they have any such ancestry. Moreover, if the group is not one of the accepted nationalities, but a foreign group, they have to prove their origins in the land back to 1823. In the case of the Kachin, because they are one of the recognized nationalities, they seem not to have experienced denial of their identity to the same extent. Rather, Kachin identity, especially as revealed in names, has over time gradually led to increasing discrimination, such as blocking of employment, appointments, and prosecution. after proving the general intention of destruction of the three groups under scrutiny, even if at different stages, and qualifying the facts as genocide under the Genocide Convention, the Tribunal went on to identify 3 of the 5 practices of the UN Genocide Convention as having been applied against the Rohingya population, such as killing members of the groups, causing serious bodily or mental harm to members of the groups, and deliberately inflicting on the group conditions of life calculated to bring about its physical destruction in whole or in part. On the strength of the evidence presented, the Tribunal reached the consensus ruling that the state of Myanmar has the intent to commit genocide against the Kachin people and the other Muslim groups. Further, the state of Myanmar is guilty of the crime of genocide against the Rohingya group. Moreover, that genocide against the Rohingya is now taking place with ongoing acts of genocide, and the possibility the casualties of that genocide could be even higher in the future if nothing is done to stop it. Regarding the other Muslim groups and the Kachin groups, even if the implementation of the genocide is not yet taking place, the Tribunal needs to issue a clear alert warning that the continuation of the process of persecution, together with crimes against humanity and war crimes, could amount to the implementation of a genocide in the near future. That's the end of the summary of the qualification of the facts. But as the Tribunal, the Permanent People's Tribunal, is a permanent People's Tribunal, we never finish with the qualification of the facts, but also with some recommendation for different actors in the situation. So Judge Jill Beringer will read the recommendations part of the judgment, and it will be read complete because it is quite important.
Recommendations. Numerous reports on the situation in Myanmar have appeared in recent months, each making significant recommendations. It is not the intention of the PPT to simply repeat what is already a substantial list of well-informed and valuable recommendations. In making our recommendations, we intend to indicate what, in our view, based on the evidence we have considered, needs to be done under conditions that currently exist, as well as longer-term actions that need to be taken to heal the wounds suffered by the people of Myanmar and to prevent further injury to them. We do this cognizant of the State Councillor's invitation to Friends of Myanmar, as we consider ourselves, to join with her government in helping to restore peace, to achieve reconciliation, and to point the way to social, political, and economic development toward a fair, just, and prosperous Myanmar under the rule of law. We also are aware that despite the best intentions of the international community in establishing the United Nations and bringing forth the Universal Declaration of Human Rights, in the shadow of dreadful events such as the Holocaust of World War II, that genocide and other atrocious crimes have been repeated time and again since 1948. Therefore, we have taken this opportunity to make some general suggestions that we believe will aid in the universally desired end, unfulfilled since 1948. Never again. The recommendations which follow are articulated with attention to their potential for being implemented in the current intense period of international debates and proposals which is accompanying the events in Myanmar. One, to stress the urgency and the need of concreteness to face effectively the immediate short-term needs of the humanitarian crisis. Two, to protect and promote the struggles for democracy of the communities most affected by discriminatory and persecutory measures and policies. Three, to assert that the failure of key national and international actors to assume effective measures in this instance would contribute to the growing crisis of credibility on the role of international laws and principles in providing peaceful solutions for conflicts where regional, global, political, and economic interests prevail over fundamental rights universally recognized as indicators of a sustainable democracy. Our recommendations. First, measures for the government and people of Myanmar. Urgent measures to minimize further harms. Recommendation 1. A ceasefire package and demilitarization should be negotiated by governments and ASEAN representatives with all armed groups in Rakhine State and the Myanmar military, including a demilitarized zone along the border in the northern region of Rakhine State. The verification process proposed by Aung San Suu Kyi and others should, without any further delay, guarantee that all persons born or naturalized in Myanmar are considered full citizens of Myanmar, and they should all be issued national identity cards with all the rights of full Myanmar citizenship. 3, Myanmar must grant visas and full access to the fact-finding mission of the UN Human Rights Council and others in order to investigate and document human rights abuses against the Rohingya, other Myanmar Muslims, Kachins, and other groups. Democracy, participation, and citizenship. Recommendation 4. Myanmar must end its official discrimination and persecution of the Rohingya, Kachin, Myanmar Muslims, and other groups. Myanmar must repeal or amend the 2008 Constitution, the 1982 Citizenship Law, and other discriminatory law and policies in order to extend full citizenship to the Rohingya and other groups, ensuring all rights guaranteed by the treaties and conventions to which Myanmar is a party, as well as the Universal Declaration of Human Rights. 5, military representation in Parliament should be abolished, and all members of Parliament should be democratically elected. Minorities should not be barred from representation in Parliament. 6, the 2008 Constitution should be amended in order to place the armed forces and police under full civilian authority. Justice and the rule of law. Recommendation 7, Myanmar must prosecute perpetrators of human rights abuses, hate crimes, genocidal massacres, rape, torture, arson, and ethnic and religious violence against the Rohingya, Kachin, Myanmar Muslims, and other groups in its courts. There must be no more impunity for military personnel, police, or militias. Human rights and accountability. An independent, non-governmental commission should be established to develop a program for rehabilitation and compensation for victims of harms to all those injured through violation of human rights. Transformation, inclusion, and inequality. Recommendation 9, recognition of the capacity of the peoples in the different states to administer their own affairs consistent with commitment to a united federal Myanmar. The reality of internal colonialism and the policy of Burmanization needs to be confronted and transformed. Measures for the government of Myanmar and its neighboring countries. 10. Myanmar and neighboring nations must allow humanitarian, human rights, religious organizations, and journalists unobstructed access to Rakhine State and Rohingya refugees, and to areas with Kachin and other national groups. Recommendation 11. There's a tendency to view the refugee flow through a security lens. Such perception is not only flawed, but may also result in improper policy responses. We urge all concerned to view refugees with compassion and humanity, and thus to highlight threats to human security of refugees rather than viewing them as a national security threat. We urge the Bangladesh government to A, issue a temporary identity document that will protect the Rohingya refugees, including those arriving in previous years, from arbitrary detention for illegal entry. And B, ensure treatment of the wounded and in due course put in place psychological support to the refugees, especially affected children and abused women. Measures for ASEAN and other members of the international community. Recommendation 12. ASEAN nations are encouraged to share responsibility for the immigration crisis and open their borders to Rohingya asylum seekers in accordance with the ASEAN Charter, and permit them to settle in refugee camps until Rohingya are granted full citizenship rights in Myanmar. 13. The European Union, United States of America, Japan, China, and other prosperous nations should provide the financial and material resources necessary to support the burden borne by Bangladesh, Malaysia, and other nations that welcome Rohingya refugees. 14. The hosting country's law enforcement agencies and community organizations must remain vigilant, while NGOs and the media should be encouraged to raise awareness about traffickers' methods and consequences of trafficking. Women and unaccompanied children are particularly vulnerable to both internal and cross-border trafficking. Measures for international and regional institutions. 15. Impose an immediate arms embargo on the government of Myanmar. 16. Targeted sanctions should be imposed on Myanmar government officials and perpetrators of human rights abuse. For example, freezing of overseas bank accounts and a ban on travel outside Myanmar. And develop a plan to escalate sanctions should the government fail in its general duty to protect its people and to stop the human rights violations by the military, private persons, and organizations. Finally, recommendation 17, an independent international non-governmental commission should be established in order to investigate the causes of and where responsibility lies for the harms about which the world has now been made aware. Thank you.
Thank you very much, Judge Beringer. So with the 17 recommendations, finishes the reading of the excerpts of the judgment of the Permanent People's Tribunal on the state crimes allegedly committed in Myanmar. So let me take the opportunity before going to the questions and answers part of the session on behalf of the panel of the judges to thanks to everyone who made possible this tribunal, particularly the steering committee and our Malaysian partners like Just International, Centra, the Buddhist Muslim Forum, for an untiring effort in ensuring the success of this tribunal session, and a really special thanks to Dr. Chandra Musaffar and to Asril Mohamed Amin and all the team who made possible this event, the University of Malaya for providing the venue for this event, all the members of the steering committee who worked a lot for the possibility to make possible this event, the prosecution team, the defense, all the people, and particularly the expert witnesses who have come from far away to give their testimony, and most importantly, our witnesses who have courageously shared their experiences and narratives with us. So thank you very much. And we will start now the session if there is any kind of questions to be answered by the panel of judges. I don't know if there is a mic or if the question should be done here. If any of the organizers can tell me that. There's no mic, so you should come to make the questions here. Oh, it is possible to use that, or? Huh? Okay, just come. Try.
Alistair McKeach from the University of Melbourne in Australia. I was just curious, now that you've got the recommendations, we've got the final judgment, who does that then get sent to, and what do you hope will happen? Because I work with Royal Commissions back in Australia, and we see hundreds of recommendations made through these things, and unfortunately, at least in our jurisdiction, very rarely anything happens, and I'm not trying to be critical, but I'm actually genuinely curious, because recommendations can be aspirational, but how does the world, two-part question, who do the recommendations go to, and how does the world community turn these recommendations from being aspirational to actual?
Interesting question. First of all, regarding the list of the institution, the judgment is sent to a lot of international, regional institutions, governments. The Permanent People's Tribunal Secretariat would give you, after the session, the full list, which is very long. But I always insist, and that's my personal view, but I always insist that the importance of a People's Tribunal is not our confidence in that institutions, that anyway we send all the recommendations, but our trust on the communities, on the people, all over the world, trying to make any efforts to stop these atrocities, to the communities in Myanmar, to strengthen the ties among the different communities. That's why we have organized the session together with the different experience of the different groups, and I would hope that other groups could also be included in further sessions if they are done, because one of the possibilities to confront the genocidal aim is to confront the racist ideology that oppose one group to another. And personally, I do think that it is much more important and possible than what the other institutions can do. Beyond that, we are issuing a lot of recommendations to be sent to many institutions that should act immediately to stop the atrocities.
Yes, I think Daniel has given a very good it's given a very good and comprehensive answer, and I would also say that with social media now, it's a lot easier to reach thousands, if not millions, of people, and no doubt after this session is over, we will be emailing and putting on Facebook and tweeting and so forth, and sending out the document with our recommendations, and thereby providing ammunition, if I can use that word in this context, to those groups who, in the end, bear the responsibility for seeing to it that action is taken. Thanks for your question.
Okay.
And for those journalists here in the audience, I hope you will be doing much the same thing, getting the story out through your newspapers and TV, whatever else you represent. So thanks for being here.
Great, thanks for your time.
I know it is a bit intimidating to come here, but it seems that's the system. So if you are interested, just come close to be able to ask later. And please present yourselves before asking.
My understanding is that you did not mention or use the term ethnic cleansing. Rather, you have used genocide. Do you think that after your pronouncement of judgment, the international community, especially the press and the United Nations, will change their position to use the term regarding the using the term genocide rather than ethnic cleansing?
Can you state your
and
name
my,
and organization?
I am Mizanur Rahman Khan. I represent the daily Pratham Alo, which means the light of the dawn. This is the leading Bengali newspaper in Bangladesh. And my another question, actually my friend Deputy, I would like to draw his attention also whether its position reflects the position of prosecution team or it reflects the position of his own. He actually mentioned in his written submission that Bangladesh should be strongly condemned. I'm sure that when the entire international community is appreciating the Bangladesh's position hosting so many refugees, and you know we know that Bangladesh is one of the densely populated country. So whether this position reflects the position of PPT or it is an individual assertion.
Okay, regarding your first question, which is very incisive, why we didn't use the word ethnic cleansing, I would say that ethnic cleansing is a euphemism, is a way to not to call the facts as they are, and it is a concept created by the perpetrators, and it doesn't exist in any international law. So when you're saying that there is an ethnic cleansing, on the one hand, you are saying almost nothing, legally speaking. On the other hand, you are using the words of the perpetrators. You are saying that there is a kind of cleaning of the land. To think about peoples with the term of cleansing, it is absolutely, it's re-victimizing that people. So the Permanent People's Tribunals wants to call the facts for the names they have. And in this case, as it was developed in the qualification of the facts, the name we think is the name for what the Rohingya population are suffering now, and it is taking place now, is genocide. And regarding your question about if the United Nations or other bodies would start to call the facts by its proper name, so it is not us who are in that bodies, so I hope so. I really
Do you think
hope so.
it is unfortunate for the part of United Nations to use deliberately ethnic cleansing rather than crime against humanity or war crimes or genocide?
Well, but it is a question you have to do to the United Nations. So why do they use the word of the perpetrators and a word that I do think that the United Nations members know a little bit about law, so they know that they are using a word that doesn't exist in law. So it is a good question, but not for us. It is for them. I don't know if other of the judges has any answer about the second question.
Well, from my reading of the press and watching the news on TV, my impression is that there's been maybe a tipping point, and that high officials in international organizations and politicians have been using the word genocide. Some calling it a slow genocide or something of that nature. But I think it is more commonly now being accepted with regard to Myanmar. And just a little note of my own, I think ethnic cleansing is used because a lot of people are, rightly or wrongly, well, wrongly in my view, understandably because of the culture and the media and so forth, a lot of people are comfortable with ethnic cleansing, and they kind of understand that, well, you know, if you move people to another location, what's the difference? Then there won't be any conflict. So it has a number of very strange ideological attachments to it, whereas it's very hard to defend genocide.
So my second question was the mentioning from prosecution that Bangladesh should be condemned.
May I respond? That was obviously done in the course of my speech, but I take that as a personal opinion, and that it does not reflect the position of the prosecution team.
I think we should let other people ask that.
Okay.
He settled that question.
Thank you.
If I may add, it was the media that painted a very poor picture of Bangladeshis pushing out refugees out to the sea. But at this tribunal, and with all the research reports, and especially after Prime Minister showed her concern for the influx of the Rohingyas into Bangladesh recently, and said that she would do all she could. And from our expert witnesses here, we are of the view that we need to help ASEAN and the international agencies. We need to go out and help Bangladesh deal with this problem. And if I may add, what is happening in Bangladesh, all the problems associated with accommodating all these refugees, could become a problem, as someone once used the term, secondary flows to Malaysia. So we should appreciate, we should go there and help. Apart from us going there with humanitarian aid, we should learn from the Bangladeshi situation. Okay.
Yes, it's Helen and then...
morning. I'm sorry, just a little more on the previous question. I should like to also remind everybody that we were extremely appreciative of the appearance before the tribunal of the Commissioner of the National Human Rights Commission of Bangladesh, who came all the way from Dhaka, especially to present the view of the government and of his commission to us, which was extremely helpful in our deliberations, and we recognise that in our full report.
I just want to add a very quick point to what the other fellow judges has mentioned about the question on Bangladesh. I think we shouldn't forget the fact that the mandate of this tribunal, which was given by the community, the Kachin, Rohingya, and Muslim community, was to investigate the alleged crimes of the state of Myanmar, the international crime that was allegedly committed by the state of Myanmar, and reach to a conclusion that whether war crimes against humanity and genocide have been occurred. So I think for that reason, the panel of judges had to act based on that mandate.
Thank you very much, Judge Sadhu. So now, please present yourself.
Okay, my name is Arjunan. I'm from the EXCO of JUST, as well as an academic from the Health University. I listened to all the recommendations. It sounds very good. But Myanmar is a military-controlled sovereign state. Based on the industrial practice rules at the moment, it can ignore all your recommendations. The next point, if that's the case, the organization that should look into is the UN Human Rights Commission. If you look at the role of UN Human Rights Commission in Sri Lanka, it's not very satisfactory. If that's the case, whatever recommendation you make, will the UN Human Rights Commission pick it up and take it to the United Security Council? UN Security Council, you got the 5 permanent powers. Particularly in this context, I pick up China and the United States. Because of vested interest in the Asia-Pacific region, where's a rivalry between China and the United States. Do you think the United Nations, particularly UN Security Council, will be able to play a role in resolving this problem? Okay, coming to ASEAN, ASEAN is a club. ASEAN got a fundamental principle: will not interfere into internal affairs of the member states. So therefore, it's also difficult. All the other countries in ASEAN got their own problems. But I feel neither ASEAN can play a role. This kind of context, how do you think this matter can be resolved? Okay, one way it could be humanitarian intervention. Who could do that? Could you please answer the question? Thank you.
I would give you the same question to the first question, which is that I guess there is some assumptions, particularly in these years or in these decades, in the last 2-3 decades, in the general opinion, then the governors of the different states and the bodies are all people of good faith, and they have to know what is happening, and so they will intervene. And I think it is a very naive approach somehow, and that's why I'm so close to the Permanent People's Tribunal, to think that the real strength is in the peoples. So the government will intervene if the people of their countries will press them, will push them to intervene, either in Malaysia, or in Bangladesh, or in China, or in the United States, or whatever, wherever it be. So I think that this kind of tribunals, these kind of sessions, trying to put the peoples together, is the only tool trying to push also the social media, also different ways in which we have the academia, we have our responsibilities to push the governments to act, but not because they will understand what is happening, and they are good people that will act, but because they will be pushed to do something from their own population. It's my personal view, it's not the view of the Tribunal, but I do think that we should stop acting, I would say, as a child, just asking for their parents to do something. I think that we have to do something. So we are adults, we are not childs. So I would say, I used to feel sometimes that most of the people of the world are crying to the leaders, please do anything, and the leaders sometimes are the responsible of the situation. So what we have to do is to strengthen the ties among the different populations all over the world, among the peoples trying to act.
Just
another.
Specifically to answer your question, and we did have some discussions about all of the issues you raised. I think the general view would be that the Security Council is unlikely to be very helpful in this matter. ASEAN, I think, is a different kettle of fish, so to speak. After all, decisions about this are going to be rooted in interests. And Bangladesh has interests, Malaysia has interests, and other countries have interests here. And so there are going to be political decisions made, and as Daniel says, with pressure, internal and external. Perhaps the idea of not interfering in other people's, other countries' internal matters will not be a firm barrier. And so we may see that acting in their own interests, either from the state's point of view or from pressure from the street, we may see, and we certainly hope to see, some positive actions. As far as military intervention goes, I think the experience in the last decades would suggest that that's unlikely to be very helpful and could be very destructive. Thank you for your question.
I want to say something. I think in the event the governments fail, the legitimate organization fail, the non-state actors will move in. Say non-state actors, what I mean, the militant organizations that are based on ethnicity and religion. Okay, given the population, a big number of Muslim population in this part of South Asia, I think if the government of Myanmar failed to resolve this problem, if the international community failed to resolve this problem, if the countries in ASEAN fail to resolve these problems, I could see that militants will move into the area, and it's going to be much more difficult to handle. That's my personal opinion.
That's a real danger. Judge Nursyabani, do you want to?
Yeah, thank you. I just would like to share my experience in following up the International People's Tribunal on 1965-66 crimes against humanity and genocide that was conducted 2 years ago, where Judge Helen Jarvis and Judge Sajid serve as judge panel member. We do some, make the judgment available to the public and make a booklet to transform to the educational material to public, and also send the judgment to the Human Rights Council through UPR session. That we do lobby all the embassy in the hope that their countries in the United Nations will also raise this issue. Even though we are always attacked, on Saturday and Sunday last week, my office was attacked by the like a paramilitary and Muslim hardliner who called themselves as anti-communist party because the 65 and 66 massacre related to Communist Party coup in 1st October in 1965. But we keep going, and the main target is the young people in the hope that they will do something in the future. And we also send a judgment to all the law faculty throughout the countries.
I think it failed once.
Please, we need to move to other people. Please, Professor.
I'm not a press person, but I feel, to share, just 2 minutes, I'll take your time. Firstly, when I was coming here, many people asked, what's the point in attending this, People's Tribunal? Who's going to listen? And, what impact it would have. And in our context, I made a very strong sort of argument, said, after the genocide in Bangladesh, successive political governments, failed to prosecute those who were responsible. There were problems in prosecuting the Pakistan sort of army personnel, but the collaborators in the country, because they conveniently sort of allied with major political parties. So that was almost a forgotten thing. But it was a People's Tribunal, after about 20 years, that took place, after 25 years, that took place in Dhaka, and that really gained traction. And within a decade, political parties was forced to recognize that there has to be a closure of that. And, subsequently, the war criminals were put on dock. I have issues with how that was conducted, but surely that's a very important evidence that what type of role these People's Tribunal may have. My second point is, I guess, I'm sure for posterity, the documentation that have been provided, we have no doubt the perpetrators will be brought to justice, and the kind of evidence that has been generated through this tribunal, and you have taken into cognizance and stated, as I said, spade a spade, I think that is something that this tribunal has gained. And my final point is, the hapless Rohingyas are not getting anything anywhere from the world. And I think your pronouncement today, in unequivocal term, and backed up by judicial argument, which was so ably presented by the prosecutors, the survivors, I think that is something that history will certainly sort of view this tribunal that has made a significant contribution to genocide. Thank you very much, you honorable judges.
Thank you, Professor Abrar, for sharing with us the experience of Bangladesh, which it's interesting because after 35 years of impunity, finally the people of Bangladesh got some kind of justice, and it is somehow similar to what happened in my own country, in Argentina, in which we had also around 20 years of impunity before having the possibility to get some justice. And in both cases, it was because of the pressure from the peoples. Neither in Bangladesh nor in Argentina, and no international body was able to produce justice, but the pressure from the people after years and years in both of our cases, and almost at the same time, we were able to get some kind of justice. So thank you very much for sharing your experience.
Good morning. I'm Aslam. I'm an independent researcher. I would like to ask, since genocide is happening right now, when do you think military intervention is needed? Because as Dr. Gregory Stanton mentioned, that sometimes, throughout the history, we could see, sometimes, countries in the world actually intervened militarily to stop genocide. So I want to ask, to what extent this genocide to happen? I mean, when can we, intervene militarily to stop this genocide? Thank you.
It's a very delicate question, so I would answer only on my own, and if any other judge would like to say something, of course, it's not on behalf, it's not something that is included. As you have seen, it is not recommended in our judgment, and I would say that due to the experience of military intervention, I can't see what would be the gains of such intervention. And I would say, just thinking logically, that killing people, I don't think is the way to avoid killing people. So if you're trying to avoid killing people, it is difficult to think you will be able to do killing people. So in my opinion, when you're asking when is the moment of military intervention, I would say never. We have to do a lot of other things, trying to stop the atrocity, to encourage the peoples in Myanmar, trying to move out of the racist thinking, trying to move out of the support of the militaries, encouraging people in Bangladesh, encouraging people in other ASEAN countries, encouraging humanitarian aid, all the 17 recommendations we have done, and maybe there is more in some of the reports we have quoted, but in my opinion, never is the moment.
Thank you. Thank you. My name is Romel Shamsuddin. I'm a private individual, but I've been helping the Rohingyas since 2012, and I'm a friend of Azrael in helping interviewing the victims of the Myanmar government. One of our, I've been quite inspired by Professor Feinstein's work, especially on genocide. And recently I've read Philip Sand's East West Street on Lopetek and Lemkin. And both approach of Lopetek and Lemkin is relevant in ASEAN right now. It's whether to go for crimes against humanity or genocide. Because of ASEAN non-interference angle, it makes it quite difficult for us to either go for the individual rights or prosecuting the state. So this dilemma is what I'm trying to work with Azrael now is coming with an ASEAN-wide policy against genocide, either from the people or from the ASEAN at the bottom or the top level. What would, if we could get your help to formulate this would be very, very interesting. Thank you.
Quite a difficult question and impossible to answer, but I would say from both. The only answer I can give you is for as much as possible. So from both, I think there is a lot of things to do from the peoples, and there is a lot of things to do from the ASEAN countries. If the peoples of the ASEAN countries could push their government to understand that different ways of non-military intervention in the conflicts are in the best of all of the countries. We had an experience in our region in the UNASUR institution, which is the institution for the Latin American countries, and we had in the last decade, I would say 4 or 5 very important interventions to stop atrocities in Bolivia, in Ecuador, trying to stop them in Honduras, and it was unsuccessful because the lack of support of the US. But that regional institution never proposed to use bullets, never proposed to drop bombs, just the political humanitarian intervention in the crisis. So I think there is a lot to do from regional institutions, if you move out of this idea that what they have to do is just to invade Myanmar militarily and to think in different kind of sanctions, pressures from different governments, I think there are things to do also from the ASEAN countries, and even more than from the UN, because there is strengthened ties with the government of Myanmar in the region than an intervention from the UN.
Can I
Yeah, of course.
I'd just like to say that I don't see these as mutually exclusive courses at all, and you will see, of course, in our judgment that we have pursued the charges of we have found for war crimes, crimes against humanity, and genocide. We're not counterposing, and indeed, I would agree with Judge Firestein that we should be looking for creative and many different approaches among the communities, especially in the region.
I want to make one
I just want to make one observation and invite your Honor's comments. And then I want to call the Q&A to a close and offer Professor Chandra Mustafa, Chair of the Host Committee, the floor to make the final comment. First, my comments. I recognize that the world's premier human rights organizations, such as Human Rights Watch, Amnesty International, as well as United States Holocaust Memorial Museum, for their tremendous contributions to putting the persecution of Rohingya on the map of world's consciousness. Having said that, my observation is that these organizations that have been so thoroughly advised by learned legal minds, either practitioners or scholars, when it comes to the crime of crimes, these organizations have been extremely reluctant to call the crime of genocide by its proper name. By being so reluctant, in my opinion, they have paradoxically become an obstacle to make never again a reality. Second and finally, from the previous special rapporteur on human rights in Myanmar, Tomas O'Hara Quintana, at the Oxford Conference on Rohingyas, which some of you participated, Tomas stated publicly, after he left the mandate of the special rapporteur, that the United Nations has an unwritten policy of gagging special rapporteurs from using the G word. So genocide is not mentionable in these chambers of power. And last week, I had a public debate on Al Jazeera Inside Story with the Deputy Director of Asia Division for the Human Rights Watch, Phil Robertson. Phil, in his opening statement in the debate, stated that because UN Human Rights Commissioner and Secretary General have both used the word ethnic cleansing, which you refer to as euphemism developed by the likes of Milosevic. So when these global governing institutions and when these world's premier human rights organizations, so well endowed financially, so influential in their reach, and so thoroughly legally informed, are in this lockstep, making the circular argument, one institution deferring to the other, none of them being prepared to call the crime by its own name. Where does that leave we the people at? That's my observation, and I would like to get your comment, reaction to it. Thank you.
Yeah, thank you, Professor Sarni. And I would say that it is like the story of the naked king. So I hope that once we are calling the facts for its proper name, I hope that it will be clear that the king is naked, that the genocide is happening. And maybe I hope these institutions, which are committed to the defense of human rights, could call the crime for its proper name. We have developed just some summary of the judgment, but in the judgment and in the annexes, there is a lot of evidence presented before this tribunal and a very long and detailed legal analysis of the concept. So it can be used for anyone interested in the case. So it seems that the president of the Human Rights Commission of Bangladesh wants to speak, so I would suggest, no? No? The commissioner? Okay. I would suggest just to give him the floor before the closing statement of Professor Chandra Muzaffar. So please.
At the beginning, I like to thank the Permanent People's Tribunal for organizing such an event, and I also like to thank the organizers for supporting for this purpose. And it's an extraordinary session I witnessed, observed, and contemplated on all the things, including 13 recommendations. Before starting, I just like to highlight the government position, which has been reflected by Prime Minister Sheikh Hasina in his speech in the 72nd UNGA just yesterday. So she has specifically pointed 5 proposals, which was made very specifically. If you allow me, I just like to read out, which reflects Bangladesh's position on Rohingya. She calls upon the United Nations and the international community to immediate and effective measures for the solution of the Rohingya crisis. The proposals are, sorry, I have some problem, just I cannot read out quickly. Myanmar must unconditionally stop the violence and the practice of ethnic cleansing in the Rakhine state immediately and forever. Second, Secretary General of the United Nations should immediately send a fact-finding mission to Myanmar. I think that is also recommended by the tribunal. Third, all civilians, irrespective of religion and ethnicity, must be protected in Myanmar. For that, safe zones could be created inside Myanmar under UN supervisions. Fourth, ensure sustainable return of all forcibly displaced Rohingyas in Bangladesh to their homes in Myanmar. And last, the recommendations of Kofi Annan Commission report must be immediately implemented unconditionally and in its entirety. I think that my views is that could have been reflected in the Permanent People's Tribunal because it is the issue, I think, the Rohingya issue is mostly concerned with Bangladesh, and the views and proposal of Bangladesh, I feel, on behalf of my government, should have been reflected. And I will request to take note of this, that the UN recommendation or the Kofi Annan's, Commission's report, whether can be considered in your final proposals or not. Another thing, my respected Deputy Chief Prosecutor, he proposed, I think it's written, that Bangladesh should be condemned for putting the Rohingya peoples in certain land or corners of the country. I think the government position is very clear. This is not for making their life, miserable or more insecure, and they should not be dispersed everywhere of Bangladesh. Their identity, their security, and their existence has to be very safe, very confidently managed. If they move around everywhere, they cannot be managed, they cannot be fed. Even they can be victim by people who target them, because they have no identity. And nowhere on earth any person can be moved who is coming from without any ID card or passport, whatever it is. And I think the respected Deputy Chief Prosecutor has noticed that how well Honorable Prime Minister has been appreciated in the media because of his role regarding Rohingyas. She herself visited that place. It's a very remote and very uncomfortable place and not safe place. She talked to the Rohingya people with all her risk, mingled with them, took their views, then he formulated his, I think, 5 points. So she also declared that if Bangladesh can feed 160+ million people, why not these people? Around 800,000, expected 200,000 coming. So she also proposed that if needed, the people of Bangladesh divide their food and other facilities of life. I think this testifies the intentions of the Honorable Prime Minister as well as the people of Bangladesh, to what extent we are cooperating and thinking for the well-being of the Rohingyas. For the time being, they may be or will be put someplace for their own safety, for better management, and for their better future. Because when we negotiate with Myanmar, we have to say, these your people. If they are scattered everywhere, we cannot identify, we cannot pull them. So this is very important, putting somebody. For example, this session is happening here. I cannot move everywhere. We cannot move everywhere. So we should have a certain place. The Rohingya people are the people of Myanmar, no doubt. So they should be demarred. They should have some ID card or some verification card or some verification process. This is because, I repeat, for the welfare, for the goodness of the people of Rohingya.
Okay,
so
thank you.
I do not like to elaborate it, and that was the views of the Honorable Prime Minister, and I thank you again for giving me this opportunity to, on behalf of my people. Thank you very much.
Thank you very much for coming before the Tribunal as a representative of the government of Bangladesh. I don't know if there is any comments from the panel of judges before the closing statements. Yeah.
Yes, I just wanted to respond to the honourable representative of the government of Bangladesh. Thank you for your remarks. I would say that as far as the Kofi Annan Commission report goes, we are familiar with it, thought that there were many, many good things in it, and as I read off from our section, we know that there is we recognize a substantial list of well-informed and valuable recommendations. I didn't mention, but we actually have a footnote with a reference to his report and the work of the Human Rights Council, their reports and resolutions and so forth. And we did recognize that Bangladesh was doing what it probably everything that is possible. And we asked ASEAN and neighboring countries to help to share that responsibility, that moral responsibility, and the material strain on your resources. And I would refer you to our recommendation 11, where we do discuss and urge the Bangladesh government to issue identity cards and to ensure that the treatment of the refugees is adequate, which we know you will try to do to the best of your ability. Thank you very much.
Yeah, thank you. And I would add, we have included some of the parts of the Kofi Annan reports in our own judgment. For constraints of time, we couldn't read it, but you will find it in the judgment. We have used a lot that report, even with our differences, but it's a very good one. So, any other comment from the panel of judges? No, so I would ask Professor Chandra Muzaffar to do the closing statements as the organizer of the session.
Distinguished judges, friends, peace be with you. I would like to begin by thanking a group that has not been thanked yet. I'm referring to the remarks made by the Chief Judge, Daniel Feuerstein. The group which has not been thanked is actually the panel of judges. A very big thank you to the panel of judges on behalf of all of us. They deserve a round of applause for the tremendous work that they have done, to have been able to do this sort of work in such a short while, to have come out with a report with 17 recommendations, an analysis which is quite thorough, very comprehensive. I think it is really a praiseworthy effort that deserves accolades from everyone. Let me also thank a few other people very quickly who have not been thanked publicly. I would like to thank the Permanent People's Tribunal for taking up this issue, and in particular to the very dedicated Secretary General who has been there since 1979, Mr. Gianni Tognoni, to Simona, the work they have done. We're also very appreciative of other individuals, groups that have made this tribunal possible. I'm thinking of donors like Mark Simpson and Ko Aung, who forked out a lot of money to make this tribunal possible. It's that sort of dedication which is really extraordinary. And to the Burma Task Force USA, to Malik Mujahid, for his constant and consistent support for this endeavor. One should also mention another group which has been important in helping us with this tribunal, a group that is seldom mentioned when it comes to thanking people. It is the Malaysian police, in terms of providing security for the tribunal and for addressing a particular security concern that we had. And we are really very grateful to the Malaysian police for this. The university and other bodies have already been acknowledged in the Chief Judge's remarks. Perhaps I should also acknowledge the Law School of Queen Mary University, where the opening session was held in March 2017. And if there are others who have not been mentioned, before I mention the person that should be mentioned, I seek your forgiveness, because sometimes in a situation like this, you tend to miss certain names. But the one individual who was the driving force behind this tribunal is actually Dr. Maung Zani, and he deserves our gratitude, our appreciation. He is passionate, he is committed, so committed and so passionate about this cause that sometimes people wonder whether he's got anything else on his mind. This particular cause has consumed him totally. Friends, very quickly, let me say a few things about the tribunal, its proceedings, and the future, which I think is very important from the point of view of a civil society group, and I suppose I speak for many others who are concerned about grave challenges facing humanity of this sort. Over the last 3 days, we have heard heart-wrenching accounts from victims, from expert witnesses. We have, in a sense, been exposed to horrendous cruelty, to unspeakable brutality. For me, this is what has had the greatest impact upon me as an individual, that human beings are capable of that sort of cruelty, of that sort of brutality. But it has happened over and over again, and this will not be the last, which is why I think it is so important to remain eternally sensitive to the challenge posed by human depravity, the challenge posed by our own vices, our own shortcomings as human beings. And this is what I think the tribunal has done. I think the tribunal has called evil by its proper name. That is a great achievement. You have used terms like war crimes, crimes against humanity, genocide, according to the gravity of a particular situation. You have done it in a very methodical and systematic manner. And this, I think, is of tremendous help to all of us. Those of us involved in this campaign on behalf of the oppressed minorities of Myanmar, this is the sort of material that we can use in our campaign. And I'd like to suggest this to you, that beneath all the talk, the analysis, there is something that emerges that strikes me as very, very critical, of tremendous significance. And this is the question: can human beings who are different from one another live together within the same boundaries? Can people of different religions, cultures, of different ideologies, persuasions, can they establish a modus vivendi, a way of living together? Because from time to time, we seem to show all of us, the rest of us, that we are not capable, that we have failed, and we continue to fail. For me, as a citizen of ASEAN, this is particularly important. This is a challenge that we have to face in the context of ASEAN. Why? Because of all the regional organizations that we have in the world today, the African Union, the European Union, ALBA, CELAC, the most multi-ethnic, most multicultural, most multi-religious regional organization is ASEAN. The 615 million people who constitute ASEAN, which is where Myanmar is, our neighbor, part of our family. ASEAN is the best example of multi-ethnic, multicultural, multi-religious living on a regional basis. You cannot get any other example. And ASEAN should not fail. And ASEAN should not fail because of what is happening in a particular country, which is why we as citizens of ASEAN have a huge responsibility. We cannot allow this to continue. We know that in many ways we are powerless citizens of ASEAN. We know that our governments will not do very much. We're very much aware of that. We know that we cannot depend upon international organizations to help us beyond a certain point. In the end, it has to be the people. And of all the people in different parts of the world, it is the people of ASEAN who matter most, the 615 million in ASEAN, who must try to rectify this situation. This is why the findings of the tribunal, your analysis, your 17 recommendations, resonate with us. They mean a great deal for us. We want to carry this forward. We want to use this to persuade our governments, including the Malaysian government and other governments, that a lot of work has to be done. We want to use these recommendations and the analysis to talk to other governments outside ASEAN who are very influential as far as the situation in Myanmar is concerned. We have a lot of clout with the government in Myanmar. We want to talk to Japan, to China, to South Korea. We want to talk to the United States of America, to the European Union. We want to ask them to recognize the evil for what it is and to take remedial measures, to act, not just talk, to act. And we have this huge reservoir of material now that we can employ for this purpose. And this would be the challenge that faces us in ASEAN, and we must be prepared to shoulder this challenge. That's the challenge before us in ASEAN. And I want to conclude, friends, by noting the significance of this day, a point which the Chief Judge made, that this is the Jewish New Year. It is the Muslim New Year, Mal Hijrah, the first of Muharram, Awal Muharram. And if you look at what this means in the context of Islam, because I'm more familiar with the Muslim tradition, the notion of hijrah, of migration, which, already has a lot of meaning when we talk of what's happening in Myanmar and the flood of human beings across borders and so on. The notion of migration from persecution, discrimination, oppression in Mecca to Medina, to security, to stability. This is the unending story of the human race, this notion of migration. It is from one state to another. It is part of a struggle. And I think today what we have done is we have committed ourselves, once again, all of us, implicitly and explicitly to that struggle, the struggle of renewal, of rejuvenating ourselves, committing ourselves once again to justice, to human dignity. Let's keep that in mind. And I hope that all of us will remember this as we go home. Thank you very much. It is my pleasure to close the proceedings. Thank you.